Most drivers in America believe losing their license only happens to reckless people, the ones racing down the highway at 100 miles an hour, weaving through traffic, blowing through red lights like they're invisible. That's the picture most people have in their head. A careless driver, an irresponsible one, somebody who obviously deserves it. But after sitting through hundreds of hours of body camera footage, after reading transcripts from suppression hearings, after watching ordinary drivers sit quietly at defense tables while judges decide whether they'll be able to drive to work again, I can tell you something uncomfortable. Most licenses are not lost during dramatic moments. They are lost quietly. They are lost during routine traffic stops, administrative hearings, and paperwork decisions that happen weeks after the flashing lights fade away. And the people who lose them usually look just like you. Teachers, nurses, delivery drivers, construction workers, parents taking kids to school, people who thought they were doing something minor, people who thought they were just having a conversation, people who didn't realize that one small legal trigger had just been activated. That's the phrase I want you to remember throughout this entire conversation, legal trigger, because the modern traffic system in America doesn't revolve around whether something feels fair in the moment. It revolves around whether a legal trigger was activated. And in 2025, there are more triggers tied to your driver's license than most people realize. Some of them involve obvious conduct like DUI, but others involve administrative rules that feel small at the time and devastating weeks later. And here's where this gets complicated. A police officer standing beside your window is not the one who ultimately suspends your license. That power usually belongs to the state's Department of Motor Vehicles or a similar administrative agency. What the officer does is collect pieces of evidence, statements, or observations that activate those legal triggers. Sometimes those triggers are automatic. Sometimes they're based on what you say. Sometimes they're based on what you refuse. And sometimes they're based on what the officer interprets your behavior to mean. Which is why understanding these laws is not about memorizing technical statutes. It's about recognizing when a simple moment on the side of the road turns into a legal mechanism that starts moving long before you realize it. Let me show you what that looks like in real life. I once represented a man who worked in HVAC installation. Long hours, early mornings, lots of driving between job sites. Completely ordinary guy. No criminal record. One night he was pulled over because an officer claimed his vehicle drifted slightly across a lane line. The officer approached politely. Friendly conversation, routine questions. "Have you had anything to drink tonight?" The man laughed a little and said, "Just one beer at dinner." That sentence became a legal trigger. Now this is the part most people misunderstand. In many states today, a DUI investigation doesn't begin because the officer has proven you're impaired. It begins because the officer develops what's called reasonable suspicion of impairment, and statements like just one beer combined with late-night driving can be enough to begin field sobriety testing. The driver stepped out of the vehicle. He was nervous. Most people are. Your adrenaline spikes when you see police lights. Your fine motor skills get worse. Your balance shifts slightly, but field sobriety tests aren't graded on how calm you feel. They're graded on tiny indicators officers are trained to look for: a foot slightly raised early, a missed heel-to-toe step, an arm raised for balance. Each of those can become another legal trigger. Eventually, the officer asked for a breath test. The man refused. He believed refusal protected him. But here's where the law quietly changes the story. In nearly every state, refusing a chemical test activates an automatic administrative license suspension under implied consent laws. It doesn't require a DUI conviction. It doesn't require a criminal trial. The refusal itself becomes the legal trigger. And weeks later, that HVAC technician received a notice in the mail informing him that his license would be suspended, not because he was convicted of DUI, because he activated the trigger. Now let me be honest with you. Refusing a breath test can sometimes help a criminal defense case in court because the prosecution loses a piece of chemical evidence. But administratively, the DMV often punishes that refusal with a longer suspension than a failed test. This is one of those gray areas where criminal defense strategy and license consequences pull in different directions. And the officer standing beside your car knows this. Officers are trained to create situations where drivers unknowingly activate triggers, not because they're evil, not because they're villains, but because their job is to gather evidence, and the law rewards evidence collection. So they ask questions that seem conversational. Where are you coming from? How much did you have to drink? Do you know why I pulled you over? Each answer can become a trigger. But DUI is only one piece of the puzzle in 2025. Another trigger that quietly destroys licenses involves something called reckless driving classifications, which have expanded significantly in recent years. In some states today, driving 20 miles per hour over the speed limit is no longer treated as a simple ticket. It can be classified as reckless driving, and reckless driving isn't just a fine, it's a criminal charge. It can carry license suspension, it can add major points to your record. And here's the part most people never expect. You can be completely sober, completely cooperative, and still walk away from a traffic stop with a charge that threatens your license simply because the radar gun displayed a certain number. Now imagine that moment. You're on the highway, maybe running late, maybe keeping up with traffic. Flashing lights appear behind you. You pull over. The officer tells you the speed recorded on the radar. That number becomes the legal trigger. Everything after that becomes damage control. And that's why the psychology of the stop matters more than most people realize. When people feel accused, they want to explain themselves. They start talking quickly. I didn't realize. Everyone else was going that fast. I was trying to pass a truck. But those explanations rarely erase the trigger. Instead, they become statements recorded in the officer's report. This is the trap. Talking feels like cooperation, but legally, it often becomes evidence. Another law quietly costing drivers their licenses today involves something that seems completely harmless: touching your phone. Most states now enforce extremely strict hands-free driving laws, not just texting, not just dialing. Holding the phone itself can be enough, and in some jurisdictions, multiple violations within a short time frame trigger automatic license penalties. Think about how often people instinctively reach for their phone at a red light, checking directions, glancing at a message, holding the device for just a moment. But if an officer observes that through the windshield, the violation can start accumulating points. And once enough points stack up, the DMV doesn't ask whether you're a good person. It simply activates another legal trigger: license suspension. Here's where it gets even more complicated. Failure to appear in court for a traffic citation can also trigger a suspension in many states. People miss these court dates more often than you'd think. Sometimes the notice gets lost. Sometimes work schedules interfere. Sometimes drivers assume paying the ticket online is enough when the citation actually required a court appearance. Weeks later, they discover their license has been suspended for failure to appear. Not reckless driving, not DUI, just administrative procedure. And driving even once after that suspension becomes a new criminal offense. This is how a simple ticket slowly snowballs into something much bigger. Now I want to talk about something that almost never gets explained clearly: driving while uninsured. Insurance requirements in 2025 are aggressively enforced through electronic verification systems. Many states now automatically detect lapses in coverage through insurer reporting databases. If your policy expires, even temporarily, and you're stopped during that lapse, the legal trigger activates immediately. In some jurisdictions, that means instant license suspension until proof of insurance is filed and reinstatement fees are paid. It doesn't matter if you plan to renew tomorrow. It doesn't matter if the payment processed one day late. The trigger doesn't care about intentions. And this is where the system reveals its real character. Traffic law is less about moral judgment and more about administrative enforcement. Another trigger people rarely see coming involves accumulation of points from multiple minor violations. Speeding, failure to signal, rolling through a stop sign. Each one alone feels small, but state point systems operate like a quiet scoreboard. When the total crosses a threshold, the suspension notice arrives. No dramatic arrest, no courtroom drama, just a letter. Let me be honest with you. This is the hard truth part. Even when you understand your rights perfectly, asserting them can still make the moment uncomfortable. Officers may become more formal. The stop may take longer. You may feel the tension rise in the air. That doesn't mean you did something wrong. It means you interrupted the normal conversational rhythm officers rely on to gather information. Because the reality is, most investigations are built on voluntary statements. Drivers talk. Drivers guess. Drivers try to be polite. And politeness sometimes activates legal triggers. But there is a phrase that changes the dynamic of these encounters: A phrase defense attorneys quietly hope their clients remember. I'm going to remain silent, and I'd like to speak with an attorney. That sentence matters because it shuts down the most powerful evidence collection tool officers have: conversation. Now notice something important. Saying that phrase does not mean you refuse lawful orders. You still provide your license and registration. You still follow instructions. You simply stop providing statements. Here's where this gets complicated again. Silence does not guarantee you won't be cited or arrested. Officers can still act based on their observations, but silence prevents you from becoming the source of additional triggers. And in the courtroom later, silence can't be used against you. Now imagine two drivers in identical situations. Same traffic stop, same officer, same allegation. One driver talks for 10 minutes trying to explain. The other politely invokes the phrase and waits. Which one creates more evidence? The difference can be enormous. Let me tell you about a case that still sticks with me. A young woman pulled over for drifting within her lane late at night. The officer suspected fatigue or intoxication. She had consumed no alcohol, but she was nervous and talkative. During the conversation, she mentioned she had taken prescription medication earlier that day. That statement activated another legal trigger: possible drug impairment. The officer conducted field sobriety tests, requested a drug recognition evaluation. Eventually, the case collapsed because toxicology results showed therapeutic levels of medication with no impairment. But by then, her license had already been temporarily suspended pending the investigation, all from one conversational detail. Now imagine if she had simply invoked the phrase and limited the conversation. Maybe the outcome changes. Maybe it doesn't. But fewer triggers would have been activated. And this brings us to something most drivers underestimate: adrenaline. When those red and blue lights appear behind you, your brain enters a mild stress response. Heart rate increases. Memory retrieval becomes less reliable. People talk faster. They over-explain. Officers are trained to recognize this state. Sometimes they'll deliberately pause, waiting for you to fill the silence. Sometimes they'll ask the same question twice. Sometimes they'll phrase questions in ways that encourage admissions. It's not personal. It's investigative technique. And if they ignore your attempt to invoke silence, that happens sometimes. The best approach is calm repetition. I'm choosing to remain silent, and I'd like to speak with an attorney. No anger, no argument, just consistency. Body language matters here too. Keep your hands visible, move slowly. Avoid sudden gestures that could be misinterpreted. Stress makes people move unpredictably, and officers are trained to interpret movements through a safety lens. Calm stillness communicates cooperation without conversation. Now here's the deeper legal foundation behind all of this. The Fifth Amendment protects against self-incrimination, but that protection is strongest when clearly invoked. Courts often rule that silence alone is ambiguous unless paired with an explicit statement. That's why the phrase matters. It transforms silence into a legal boundary. And when we come back to the theme of this entire discussion, the legal trigger, you start to see the pattern. Traffic law in 2025 isn't just about driving behavior. It's about administrative systems, point accumulations, implied consent laws, insurance databases, phone usage enforcement, reckless driving thresholds, and the quiet power of statements made during a stressful moment on the side of the road. Most drivers never study these systems. They assume common sense protects them. But the law doesn't always operate on common sense. It operates on triggers. And once a trigger is activated, the process begins moving whether you understand it or not, which is why the smartest preparation isn't memorizing every statute in your state. It's rehearsing the moment when pressure hits, the flashing lights, the adrenaline, the questions, because in that moment, your brain won't perform like it does when you're calmly reading about rights online. You'll default to habit. That's why I tell people to rehearse the phrase, not once, not twice, but enough times that it feels automatic. I'm going to remain silent and I'd like to speak with an attorney. Say it out loud. Practice it the way athletes rehearse plays before a game, because when the legal triggers start appearing, and sometimes they appear faster than you expect, that one calm sentence can prevent a situation from quietly building the kind of evidence that follows you long after the traffic stop ends.